Welcome back, everyone. How are you doing, Maria?
I'm doing well, Tate. How are you doing?
Good, thanks. I'm Tate with My Court Coach. I am Maria, and we are getting started on another Q&A. Today we have a great lineup of questions that we're going to respond to, questions that have been submitted as comments to videos on the channel. By way of reminder, we are not your lawyers. And by answering these questions, we're not establishing an attorney-client relationship. And anything that you see or hear here in this live stream, you should not take it as legal advice for your particular situation. You should you can just take it as just good information or education. But if you want specific legal advice, you will have to talk to a lawyer and probably get a consultation. Okay, now who is My Court Coach? My Court Coach, we have lots of information that will be helpful to anyone who is going to be presenting argument, testimony, evidence in a court or in front of a judge. Whether you're in California or outside of California, whether you have a family law case or any type of case, we have a program that could be helpful for you. The program is called Full Court Preps, which you can find at mycourtcoach.com as well. If you have a California family law case, all the videos that you see on our channel are on our website on a California family law program. It's better if you sign up for the program on the website because there are all sorts of handouts, cheat sheets, downloadable documents that will be helpful to you, templates that you can use in your court case. Let's see, coaching. If you would like some specific coaching, legal coaching, we have that as well. We have a plan for legal coaching on the program where you sign up on the website. On the back end, you can submit written questions. There's a community forum where you get answers to your questions from a lawyer or other members of the community. And of course, you get the live conference calls where you can actually talk to a lawyer to get some legal coaching on your case. So those are all things that we offer My Court Coach. But let's get started answering some questions. Give me a second to pull this up. Okay, here we go. So our first question that we're going to respond to today is a comment on our video, how to respond to a petition to determine parental relationship, aka fatherhood. And it says, I'm having trouble filling out response for questions 6 and 9. So if we look at questions 6 and 9, Maria, can you just sort of lay the groundwork as to what this Form FL 220 is about and what is a petition to determine the parental relationship?
Yeah, absolutely. So normally this process to establish parental rights is done when the parties aren't married, but there's a child. So typically you'd have to go through the courts to have the parental rights established. And this is the form that's responding to the petition. So typically one party would be the petitioner. They would do the petition to get the process started, the parentage action. And then this particular form is responding. So if typically it would be possibly the father or somebody, one of the parents on the other end that receives this form. And now they want to either contest it or kind of accept that they are the parent to this child. So it's essentially responding to the petition in the parentage action.
Okay, and then thank you. And it can go either way. Either the mom can file this petition saying, hey, this guy's the dad, or the dad can file a petition saying, hey, I'm the dad. Is that right?
Yes, exactly.
And then so paragraph section 6 on this response is about additional statements. You can either check A, which says parentage has been determined by voluntary declaration of parentage or paternity, or B, parentage has been established in some other case, like if there's a child support case going on. maybe an out-of-state case, I'm guessing,
Mhm.
or C, public assistance is being provided to the children. So what kind of information can you provide to clarify this section C?
Absolutely. So typically, when a child's born, the hospital in and of itself will have the parents sign a voluntary declaration of paternity, basically saying they're the parents to this child. Sometimes that, if both parents are present, most of the time they'll just sign that form. So that's one of the options in that section that says we've already signed the form, parentage has already been established by virtue of voluntary declaration, filling out that form. But sometimes, let's say if the parents aren't married, mother goes into labor, they're at the hospital, dad isn't there, and he wasn't there to sign that declaration. So if they don't already have that form, then this is just a different process to try to establish parental rights and make it known that they believe they are the father to this child. So that's where this process comes in. But if they don't have the voluntary declaration already filled out and signed, you wouldn't necessarily check that box. But if there are other cases, like you mentioned, a child support case through Department of Child Support Services, they're already dealing with child support and they've already dealt with the parentage or the paternity issue through that court or through that process, then you can mark that box. If none of them apply, then you wouldn't necessarily have to check those boxes if uh, none of them are relate to your particular case.
So is there a difference between the words parentage and paternity?
Not really. In my experience, they've been pretty synonymous. I think some people like to say paternity actions, others say parentage. I know the form typically says parentage, so I don't think there's a significant difference between the two.
Yeah, I don't know that there's any either. Typically, I have always called them paternity, despite the forms, and I've always heard them referred to as paternity, again, despite the forms. I'm not sure why that is.
Yeah.
And then section 9 is about child custody and visitation, where whoever's filling out this form can say, I want legal custody, or I don't want legal custody, or physical custody or visitation. And can you just sort of explain I'm not sure exactly what this person is asking. They're saying they're having trouble filling out this response for question 6 and 9.
Mm-hmm.
Maybe, so I don't know what the trouble is that they're having. Maybe it's that they don't understand the difference between legal custody and physical custody, or custody and visitation. What do you think?
Those are my thoughts exactly too. We don't really have any context behind what this individual is struggling with or the specific questions with those sections, but generally it does go through and ask about legal custody, physical custody. So a little bit of background: legal custody is the right to make decisions for the child, essentially, health, education, overall well-being. If parents share that jointly, then they're both in that decision-making process, as you have to confer with one another. Physical custody is who the child lives with. So that parent typically ends up being the custodial parent. The other parent is considered the non-custodial or the visiting parent. So those are things that if maybe they've already talked about or have some sort of arrangement, then parents, whoever's responding, can fill out that section of the document. There are attachments, there are other forms if they want to really outline the terms of their parenting plan and what that looks like. If they don't know at all, then they would have to possibly fill it out the best as possible of what they are looking for, what they would like to see happen with legal custody and physical custody. And of course, that's a bigger area that they would probably need more information about to feel comfortable filling out that section. But in general, we don't know what this person's struggling with. So they might be wondering what legal and physical custody are or what to put. Or maybe they're contesting parentage or paternity and they don't necessarily want to deal with the custody part. There are people that want to do genetic testing first before they figure out custody. So that could also be part of the dilemma too.
Yeah, good point. So if that's the situation, do they not check the box for number 9?
What I would recommend, or at least in my opinion, it might be useful or helpful to maybe do genetic testing outside of the court, maybe just on their own, just to get that information too, because then that way it'd make it more clear whether they are the parent or not. So then they can determine custody and what they want to do about that. If they're just requesting the genetic testing through the courts themselves, and they haven't done the testing outside of court, you could potentially leave that blank or to be determined, essentially, if you're mainly just responding in order to request the genetic testing.
Okay, good info. Now, for those viewers out there who aren't familiar, if you have questions about a form, go to the homepage of the channel on our YouTube channel and find the search bar, or better yet, find the playlists. And the playlists are going to have videos that are relevant to your questions. So, for example, here we have a playlist on child custody in California family court. You're going to have the answers to these questions about what is legal custody and physical custody here in this playlist. Or you can go to the search bar and you can just do a search for legal custody. I'm not sure if we actually haven't done this yet. So legal standards when making child custody decisions. So there you go. So just do a search of the channel. You're going to find helpful information probably. Okay. I think that pretty well answers that question. What do you think?
I think so too. Without knowing more, I think we've kind of covered the general questions or issues the person might be having.
All right, let's see what the next question is. Now, we have a video, how to terminate your marriage even when the family court case continues, and this is about bifurcation. And I think here the discussion is about bifurcating in order to litigate property issues, retirement, what happens with the house, resolve the child custody issues or child visitation or support issues, or just the status so that you can take time to litigate property issues. I'm guessing I haven't actually looked at the video in a while, but this question is, can you not do the opposite? That's why I'm guessing it says that, because he uses the word opposite. Can you not do the opposite as the first option and bifurcate to resolve all property division while the custody piece drags on? I'm not sure if you had a chance to look at this video, but what do you think about this?
Yeah, generally when we talk about bifurcation, we're mainly dealing with the status issue. So we're mainly dealing with the marital relationship in and of itself. What we are essentially doing is having the court say, okay, we're going to bifurcate the issue. We're going to say you guys are no longer married while we're figuring out and litigating the rest of the issues. And that could be, like you said, the property issues, the custody, support, what have you. So those other issues still need to be litigated. And if there's no agreement, if they're dragging on, essentially it could even go to trial. But really, when we're talking about bifurcation, it's just for status. So that way the court can make a determination if they're going to end the marital relationship while they're figuring out the rest of the issues, or if that's going to be dealt with altogether as a whole. So to answer their question, I don't think the court would necessarily bifurcate simply to resolve a property issue, but they may bifurcate to resolve the status issue while the rest of the issues are being determined.
And so even though the divorce case goes on, if you bifurcate to resolve the status issue, what you're saying is you're going to be divorced. Even though your divorce case is continuing, you will be divorced.
Exactly. Mm-hmm.
All right. And so what's the benefit of that? Why do people want to say, okay, I'm going to be divorced, earlier at 6 months after I file a petition rather than 2 years after I file the original divorce petition?
Well, I mean, it could vary. Maybe they want to get married again. Maybe they've been seeing somebody and they're planning on getting married, and there's maybe a time frame. They don't necessarily want to wait until the divorce all these issues are resolved, because that could take years. So if they're planning on getting married and they want to be legally divorced to be essentially free to remarry, that's one way. Maybe for insurance or benefits, if maybe one spouse is on the other spouse's insurance, then it's more beneficial to not have to have both of them on the same insurance plan. Or, there could be logistical reasons such as the insurance, or it could be more personal matters like wanting to get remarried. Those are the main two that I usually see.
Now, do you have to, let's say it's the wife wants to bifurcate, because she wants to change her name. Does she have to have the bifurcation before she changes her name? Let's say she wants to go back to a maiden name.
Well, you do need an order. You need something from the court basically saying you're no longer married and that you can change your name back to your maiden name. It would have to be essentially in an order. So I have seen that happen where they bifurcate, they're no longer married, and now they get an order from the judge, or they request that their maiden name be reestablished. So that does happen, yes.
And we have a video on that if anyone has questions about that. Okay, excellent. Anything else to say about this?
No, I think that covers it.
Okay. I think so too. All right. Here's a question on our video. X violating court orders, request a contempt hearing. We often get questions about contempt.
Mm-hmm.
People need to start obeying court orders more often. It seems like everyone seems to violate court orders. I'm guessing that's why we have so many questions on contempt. This is Form FL 410. And the question says, material facts. Can I attempt to subpoena financial documents to support my claim that he did have the ability to comply? So I'm taking this as not sure if it's a wife or mom or the ex anyway, but this lady is saying, I guess my ex was not complying with the court orders, and I know that he was able to comply, and I think there are financial documents that will prove that he was able to comply. What do you think?
Well, I wonder what the order says. I mean, if they're subpoenaing financial records, I'm assuming it's a support order. They're possibly in contempt for not paying support, whether it's spousal or child. So my assumption is that they want financial records to show, well, they had the ability to pay because they have money or they have the income to support this compliance with the court order, and they're simply choosing not to. I mean, part of the contempt action, you do need to have proof, you do need to have evidence, you do need to present your case. So whether that's through subpoena, whether it's through maybe a discovery process, maybe getting those records, I think would be helpful if that's part of their argument to show they had the ability and they're simply choosing not to.
Yeah, so the answer is yes, right? She has the ability to subpoena. We have a playlist on the YouTube channel about discovery and how to obtain evidence. And something that's unique to divorce cases or family law cases that does not apply in other civil cases is that the spouses have responsibilities. They owe the other person a responsibility to be open and transparent and to give evidence. So there are ways that I think you can get these financial records without using a subpoena, as I recall.
Mm-hmm. Right.
Comments about that?
Well, if it's a joint account, it's easier, depending on what type of financial institution or account they're trying to tap into. That also is a question of whether they need the subpoena or not. Generally, like you said, spouses do have that fiduciary duty to one another. People do hide money too. So I can also understand that maybe there's other accounts or there's other resources that perhaps they're trying to tap into. Again, I'm not really sure about the context behind the question, but yes, they can try to get documents or evidence to present in a contempt action, whether it's through a subpoena or otherwise.
Mm-hmm. Yeah, great. Now we have videos on how to fill out the subpoena. So take a look at that. I'm actually going to go to another question that's also about subpoenas. And let me share that. So on our video, avoid this mistake when issuing a subpoena for records. Use the consumer notice. Well, that is a common mistake. This question says, she says, I'm sorry, but do you know how much this euros cost in I'm guessing it's Los Angeles, Lord Angeles.
Mm-hmm.
And if you have voucher that covers the paperwork you file, will cover the subpoena. Thank you. Not entirely sure, honestly, what the question is. Sounds like she's saying, how much does it cost to issue a subpoena? And can I get that waived? I don't know. What do you think she's asking?
I think so. I don't know how much it would cost in euros because it's usually in dollars, so I wouldn't really be able to address the euro question. And as far as fees, there are fees involved in getting a subpoena, a voucher. Perhaps they're referring to a fee waiver, which I don't, I'm not particularly sure that that would apply, but I think that's what the question is asking, how much it would cost in euros, which I don't know if either one of us really know. And then, if they can get a fee waiver for the subpoena or if there's costs involved with that.
What are costs involved with issuing a subpoena?
Well, there are costs involved to the paperwork, the filing, the service, depending on what type of subpoena as well, whether you're just trying to get somebody to provide information, if you're trying to subpoena financial institution or consumer, get business records, if you're trying to subpoena somebody to come to a hearing, that's different because typically there are costs involved in getting the witness to come to the hearing, paying for their time, their travel. So there are various costs associated depending on what type of subpoena and what you're trying to use it for.
Yeah, witness fees. So the fee waiver that Maria was just talking about, that's a court can say, I'm not going to charge you. You're not going to have to pay to file documents in the court. I don't think that really applies to a subpoena. A subpoena, you're not serving the court with a subpoena, that you're serving other people with a subpoena. So there's no filing fee, so far as I know, with that.
Right.
I don't think there would be any kind of fee waiver applying to a subpoena that I know of.
Right. The fee waivers I typically see are the initial pleadings, right? So if you're filing a petition with the court or responding, so typically you can get fee waivers for those if it applies, if you qualify for it. But beyond that, I haven't really seen fee waivers applied, especially for a subpoena.
Yeah, and so when it comes to serving, you can't serve a subpoena yourself. Let's say you want, I don't know what financial records you want. I don't know if you want, retirement information, or if you want to serve, Wells Fargo, because your ex banks at Wells Fargo. But you're going to have to get them served, and you can't do it yourself. If you can't get a friend to do it, then you're going to hire a professional process server. Mm-hmm. Maybe you can get the county sheriffs to do it. I don't know if they're free. I think they're free. If they're not free, they're cheap. Mm-hmm. Do you know anything about getting the sheriffs to serve legal documents?
I'm not entirely sure. I have seen it for restraining orders and DV cases, but just regular subpoenas or trying to serve a county, that I'm not entirely sure of. Or you're also referring to using a sheriff to serve an individual, right? I'm not entirely sure if it's free or if there's a charge for it.
I don't even know if they'll do it. The only time I've ever used sheriffs is in a restraining order situation, which they do for free.
Right.
But have them serve like Wells Fargo, I don't think it's going to happen. Yeah. So no, I don't know of any other way of covering the costs of that. Litigation is expensive.
I was just thinking the same exact thing. There's a lot of expenses and fees and costs that are involved with litigating any case.
Yeah, and that's why we're here. We're trying to help you avoid the expenses of lawyers and litigation, but we can't solve all your financial troubles, I guess. But we do what we can. Mm-hmm. All right, I think that's really all I have to say about that one. What do you think?
Yeah, I think so too.
Okay, our next question is on the video: how to fill out the income and expense declaration in California Family Court. There are always questions about this form. I used to always call it the I&E form. Other people call it the IED. What's your habit? What do you call it?
I&E. I've seen the IED too, but I'm with you. I say the I&E too.
Good. I'm not alone. This question is, what if you are 18 years old, getting a divorce, and have never filed taxes? Can I just leave number 3 empty? And what he's talking about is number 3 on this form is about tax information. The different options on this number 3 is, you can say 3A is, I last filed taxes for tax year, whatever, you indicate the year. 3B, you can say my tax filing status is single or a head of household, or married filing separately, or married filing jointly if you're married to somebody else. Or 3C, I file state tax returns in, and then you indicate the state. Or 3D, I claim the following number of exemptions. I guess this isn't or. This isn't an or. It's just you're stating how many exemptions you claim when you're filing taxes. And so he's saying, well, I don't pay taxes. So, what do I do? What are your comments here?
I've actually never encountered that type of situation, because in most cases people have filed taxes. They usually have something to put in that section. Now, if they've never filed taxes, it doesn't apply. I mean, arguably they wouldn't have any information to include, because none of that would be applicable in their particular case. So I would assume this particular individual would be able to leave it blank, but in an abundance of caution, I've also seen people they create a text box if they have the platform for it. You can create a text box and put maybe something along the lines of never filed taxes or something, just to put some sort of wording in there. But arguably, if they have no information to put in there, they wouldn't necessarily have to fill it out. If there's issues, if the other person or the judge has questions about it, you can address it at the time either of the hearing or if necessary. But yeah, I think if they've never filed taxes, they don't have information to include for that section.
Yeah, there are lots of people who don't file taxes. Homemakers and just anyone who doesn't have employment, 18-year-olds, like he says.
Mm-hmm.
I've had mixed results on writing something into a judicial council form like this and submitting it to the courts. I've had courts accept it and say, okay, well, you wrote something different on there and fine. I've also seen court clerks who have rejected those forms when I've added something like another option. I've only seen that happen a few times where it's been rejected. Usually they'll go ahead and accept it anyway, or you can file it on demand, I guess. But yeah, I would say just leave it blank and see what happens.
Yeah. If they have issues with it, it can always be addressed later.
Yeah, what you don't want to do is put down something that's false, because the income and expense declaration, I believe at the very bottom of it, you're signing this under penalty of perjury.
Right.
Yeah. If you have any update on this, if you actually filed this and you wrote something on it, or if you left it blank, let us know. We put a comment down below. We'd love to hear what happened.
Absolutely.
Okay. Anything more about that one?
I don't think so. And depending on the type of case, sometimes these INEs are updated. So if at any other point that this individual does end up filing taxes, then and the case is still going, then they could perhaps include that information in an updated INE or IED.
Right. Good point. Okay, we have one more comment to go over. And this is on our video, when to use a declaration for default or uncontested divorce in California Family Court. This is regarding FL 170. And this commenter, she says, question number 7. So this is regarding paragraph 7 on this form. Let's see if I can get there. Here we go. This is regarding child support. She says, if there's a written agreement on child support, what do I write? Reserved by court, or do I have to mark a box? And so there's under this form, there's section 7, there's option A or there's option B. And option A is so it says child support should be ordered as set forth in the proposed judgment. And if there are minor children, check and complete the appropriate response here, or section B is regards to public assistance. What comment do you have on this?
So usually if there's an agreement, the best practice is to have an attachment that outlines the terms of the agreement and that you would include with this document and the proposed judgment. So you can typically put the proposed judgment, the terms in the proposed judgment, and then also again, have the attachment with the agreement as well. That way, again, you're not just relying on this form or the proposed judgment, but you are also including the terms of the agreement too. So it's abundantly clear what those terms are.
Okay. And what does she write here then? Yeah. Can she leave the blank? Can she leave the box blank then?
Right. And then just mark the proposed judgment, the FL 180 as well, because it would have to be reflected in the proposed judgment as well. The terms of the agreement, what they're proposing the judgment to be, that would be a separate attachment or a separate form that's included as the packet. So she can probably just mark that box.
Okay. All right. Got it. Yeah. All right. Sorry, I got lost there for a second. And then question 8 is about spousal support or partner support or family support. The question says, if we have a written agreement, do I only mark 8D, written agreement, or can I also check off B, respondent, and C, petitioner?
Again, it's the same thing. I mean, if there are terms for support, it would be in the agreement that you would attach with the form, again, as the whole packet in the proposed order as well. So it's a similar concept.
Will this agreement be a marital settlement agreement or something else?
It could be. It could be. So typically, if it's a default case, meaning the petitioner filed it, they served the other spouse or the other party, they didn't respond within the 30 days, either intentionally or they just simply they didn't show up in the case. And now you're moving forward in a default. Sometimes people that have an agreement, they choose not to for various reasons. Maybe they don't want to pay the filing fee to appear in the case, or they're just in agreement on everything. So they're fine with it going as a default or uncontested divorce. So if they have a verbal agreement, then you would outline it as a written agreement, put all the terms in a form essentially, and that becomes like a stipulated judgment, or in this case, a default with an agreement. So yes, it would outline all the terms of everything that's involved. So if there are custody issues, property division issues, support issues, all of that would be detailed and outlined and all included as a packet to the court.
So you can have a default with an agreement. That sounds so weird.
Yeah.
Or uncontested. Could you have uncontested with an agreement?
Yeah, absolutely. It's the similar thing. They're just not contesting any of the issues. They're not fighting over everything. They're in full agreement on how custody is going to work if that's an issue. Or again, all the various issues, they're in complete agreement. They're both on the same page. And now they just need the documents to reflect that agreement.
Okay, perfect. Thank you. Now we have a question or a few comments here. I don't know if you can see those.
I can't on my end.
If you hit comments, maybe you'll be able to see it. Angela, she says, what about if spouse lies saying he spent $16,400 a month on me? Clearly not true. He lied about everything on his paperwork. Can the judge do anything if I bring that up? I just turned in my request for order on Friday. Haven't heard from the court. I'm calling right now after this video. My spouse says the judge will make orders. He thinks it's just a file case closed because he no longer wants to be with me. He has a new girl. Sorry to hear that, Angela.
Yeah.
Sorry to hear he's lying. So it sounds like Angela has filed, she filed an RFO. Not sure what issues did you file in the RFO? And she's basically saying, if he lies, what can the judge do about it? If I bring that up, what can the judge do?
Well, and again, I'm with Tate. I'm sorry that you're having to go through this. It's never easy to try to deal with it looks like it's a divorce and have all these issues that now you're trying to present to the court. If you believe he lied and he spent money and that paperwork would be relevant, the judge would need to see that. So if you're claiming that he is lying, that he's been misappropriating funds or, disposing of marital funds without your consent or without your knowledge, then you would still need that paper trail. Anything you do with the court, you do need evidence. You do need to have documents and information to present to the judge because the judge would want to see that information. Now, how you go about it, there's various processes and one avenue is what we talked about earlier. If you want to engage in discovery, that's one method and one technique to try to get documents. But yes, if you're claiming that he lied and there's all these various issues for whichever request for order that you're dealing with, you would need to either subpoena or find ways to track some of the transactions to be able to present to the judge.
Mm-hmm. Yeah, sorry to hear about your situation, Angela, that this is still going on. I remember seeing your comments in other live streams. So she says she's living out of her van and destitute. Like we talked about expenses for litigating and serving documents. That's hard to do when you're destitute. You can also file, if you have that filing fee waiver, you can file a request that he have to pay for costs. I imagine we have a video on the channel about that. Can you say anything about that?
Yes. So if there are costs involved, typically if you were to have an attorney, you can ask for the other side to pay the attorney's fees. In this case, if you're self-represented and you have costs involved, as long as you can show a disparity of income, then you can argue to the judge that the other side would have no prejudice, there's no financial burden, and they should be able to bear those costs for you. Another option is potentially legal aid. I know there are some local legal aids that can help with the legal process. And of course, they have their scope of what they can help with or not. Some can go to court with you. So typically, with financials are concerned, legal aid is definitely another great option or a way to still be able to present your case and have assistance in it.
Yeah, I guess I don't really understand why he's saying he spent $16,000 a month on you. I don't know if he's saying this is in your medical bills, or if he's saying he's been contributing to you, and you're saying no, he's not. He's spending $16,000 a month on gambling or whatever he's spending on a new girl, whatever he's doing. I don't know. When it comes to like spousal support, usually the obligor, if it's the guy who has the money, he's trying to minimize how much money he has, and he's trying to say that we didn't live these lavish lifestyles. We had very a lifestyle that was not very expensive, right? And so therefore I shouldn't have to pay you a lot of money because you were living on a modest lifestyle in the beginning. I don't know. I don't really understand this, what he's doing. What do you think, Maria?
Yeah, I mean, it does sound like he's trying to avoid spousal support, or at least try to claim a certain marital standard of living. Now, again, having to try to prove that, it would come down to the finances, the dollar amounts, the papers, the transactions, and trying to prove either the lifestyle or where the money is going. So saying that he lied, and I'm sure he very well could have. We don't really know, but it's one thing to claim it, but it's another to try to prove that to the court too. So I think depending on the situation, then it would need to be through the paperwork itself.
Okay, right. And she says that he is her financial sponsor, I-864. I don't remember what that is, if that's an immigration thing.
It sounds like it's immigration, yeah.
I think we actually discussed this on a previous live stream. I was going to say something now. I don't remember what it was. It's when a judge is trying to make decisions about dollar amounts and how much one party owes another party, it's really not enough to say that he's lying. Because what is the judge going to do with that? Okay, let's say he says, according to your ex, based on the numbers, he should have to pay you no spousal support at all. And you're saying he's lying. Well, that doesn't exactly tell the judge what to do. It's not enough to say he's lying. You have to actually give the judge actionable information. You have to say, it's not 16,000, it's 20,000 or 5,000 or whatever it is.
Mhm.
You know what I'm saying? So you actually have to affirmatively give the judge the information that you think is accurate rather than just say, no, he's lying. That's probably obvious, but I just wanted to say that. Any comments about that?
No, I agree. Yeah, I think that's the point I was also trying to get at, but you explained it really clearly. So thank you.
Well, let's see. I don't know how else we can help you except hopefully your RFO does have the information the judge needs. If it does not at this point have that information, seek that information out through the discovery process. And if you have an RFO, you must have a court hearing coming up. And if you need more time to gather the evidence to give the judge the right information, take a look at how to do that, how to request a continuance if you need that. Hopefully you don't need that. And hopefully all of the information is attached to your RFO.
Mhm.
Okay. Well, I think that's all we have today. Maria, any parting comments?
No, I just hope this information was helpful, that we addressed the comments and the questions and were able to provide guidance that was useful and helpful to the issues that we covered today, and to keep them coming. We're happy to jump on these live streams and answer questions and provide guidance.
Absolutely. Wish you well, Angela. Maria, thanks for your help. Remember, go to mycourtcoach.com. You can find all sorts of resources to help you represent yourself in court and to win in court. Whether you need help learning how to present evidence, present testimony, present argument, if that's your situation, you should get the full court preps. If you need help presenting or how to manage your family law case in California, sign up for the California Family Law Program. It's free. And there's all sorts of templates and good resources there. And if you need some coaching, if you want to talk to a lawyer every day, you can do that. Sign up for the coaching program. And you will save thousands and thousands and thousands, literally many thousands of dollars on attorney fees by signing up with our coaching program. You can get feedback on our online forum, our community forum on the website, and also through conference calls. Okay, that's it for today. We hope to see you again on our next live stream. Thanks, Angela. Thumbs up to you. And until next time, adios.
Bye, everyone. Have a good day.